Okay, good evening, everyone. I would like to call to order the regular monthly meeting of the Town of Rhinebeck Planning Board it was scheduled for Monday, February 2nd. As you all know, with the storm yesterday, it was postponed until today, Tuesday, February 3rd, and I want to express my appreciation to the members of the board for making themselves available tonight and for as many of the applicants who could make it in. I know it's disruptive, but our other choice was to postpone it, to next month, and we thought it was better for everybody if we could move as much of this ahead as we've been able to. So thank you again. I would like to start the evening by welcoming Eric Blome, who has just become a member of the planning board at the appointment of the town. Eric, you want to tell the public a little bit about your background?
All right, I'm an engineer, a mechanical engineer, and been working for the last 40-some years in the field of special structures, which is non-standard construction items.
Well, welcome.
Thank you.
We're happy to have Eric join us. That brings us to 6 members of the planning board. We're still vacant 1 planning board member. So again, I would encourage you to reach out to people who are interested and encourage them to submit their application to the town board for review. You've all received the meeting agenda. I trust you've all had a chance to look at it. One of the things that's changed since the agenda was published is that the consultants, both any legal attorney or an engineer consultant for Astor Courts, was not able to make the meeting this evening because of the change in date. And so a request has been made that we continue the public hearing until the March meeting when the representatives of the applicant can be present. Is there any questions?
What you need is a motion.
I do.
To defer the continuation to the March 2nd meeting at 6:35.
So moved. Second.
All those in favor?
Aye.
Opposed? Abstentions? Thank you. We're sorry for the inconvenience, Kathy. And
There's a complement to that change. While the public hearing is not being continued this evening, Astor Courts will remain on the agenda under old business as a ministerial item.
Correct.
Among other matters being the possibility of the planning board adopting a resolution to authorizing the issuance of a secret notice of intent and things of that sort.
Right, but the point of the motion was that we will not be continuing the public hearing this evening. We'll be deferring that until the March meeting. Okay, you've also been, I think, inundated over the last few days with minutes. And I'm assuming, I don't want to jump to any conclusions, but I'm assuming that you've had a chance to look at some of them, but perhaps not all of them. If my records are correct, the minutes of September 15th, October 20th, in the agenda it's incorrectly listed as the 13th, December 15th and January 5th, 2015, should be ready for review. I don't know whether that agrees with your perception or not, but what is your pleasure this evening? For the purposes of the public, we've been trying to catch up on minutes, and we also have received the minutes of April 7, May 5th, June 2nd, August 18, and the special meetings of February.
Those are the ones outstanding.
Oh, the ones outstanding.
Right, you've actually received, and I don't think they're ripe for considerations this evening. You have additionally received the minutes of September 15th, October 20th. No, hold it. No, those are the ones that are right. Oh, here we are. June 25th, May 19th, June 25th, and August 18th.
Yes.
Those you probably have just received this evening. They were just reviewed yesterday.
Okay, so what is your pleasure this evening?
My take is take them all, bundle them, do them next month after we've all had a chance to read them. Because they came in my email today, and I worked all day. I had
Sure.
no opportunity to even open it up.
I agree. Any dissension on that? All right, so please take them, and if there are any that come in the meantime, let's try and get the ones that come in so that we can bundle them together for review and acceptance next month.
You have 7 sets right now in front of you.
I have
Do you have any
7.
reason to believe that there are more than 7? I
Oh,
don't.
yes, yes.
Okay,
Yes.
okay.
And before we,
4 more times.
4 more coming that we are expecting. All right, before we open the public hearings for this evening, I'd also like to report back, and I have shared this with the other members of the planning board. At last month's meeting, Woody asked what the status was of our, or the necessity of our having to read all the resolutions into the record. As some of you know, sometimes these resolutions are very long and they extend meetings, we thought perhaps unnecessarily. And so we did direct that question to our attorney, planning board attorney, and he has responded to us that the short answer is it is not necessary to read the resolutions into the record, although it can be a worthwhile practice, and that practice being moving ahead to the conditions of the resolution so that those are clear. In the future, Brennan is going to be working with us to have those resolutions copied so that they're available to the audience who comes here and they can take them with us. But we'll be working to kind of streamline that part of our agenda and reading only those parts of the resolutions that are absolutely important to be read. Did you all have any questions about that? Is that satisfactory to all of you?
Great to me.
Okay. All right, next up, it is after 6:35, so let's jump in. Our first public hearing this evening is Rhinebeck Gardens Group LLC, Garden Way between Astor Drive and New York State Route 308 site plan. This is the conduct of a public hearing on an application for amendment of approved site plan, Planning Board Resolution of September 19, 2011, for Phase 3 of Gardens at Rhinebeck Residential Development within the Rural Agricultural RA District, and LWRA being deemed by the Planning Board to be consistent with the overall project, subject of a negative declaration, determination of non-significance issued by the Planning Board as seeker lead agency on September 19, 2011. Good evening.
Good evening. My name is Christopher Lapine with the Chase & Companies, representing the applicant this evening. I've just given all the affidavit and all our mail. So we're here this evening simply to ask for some minor modifications to Phase 3, which was previously approved. These modifications are similar to the ones that we came back with for Phase 2, which were amenable to the applicant at that time. And we also are seeking some other modifications to typical units, which we've seen a more desirable need for in Phase 2. Similar to Phase 2, we eliminated the common refuse areas, and we are seeking to have individual refuse pickup at each individual dwelling. We are seeking the options for a 10-foot by 10-foot deck over B units, similar to Phase 2. We want to demo what was the existing building there and create one that's similar to all the other buildings that we're going to be developing around it. As I indicated, there was a desire for the one-story units in Phase 2, and quite honestly, there wasn't enough to accommodate all the requests. So what we did was we supplemented a number of units on this plan and added some more C units to the ends. They were buildings 42, 45, 60, 62, 47, 48, 54, and 63. This was about it. We maintained the 50-foot separation between the units that we had to. We maintained the 4 units per what the original 1987 special use permit was for that project. We did have some comments that I spoke about our last meeting in January that we had gotten from the zoning board administrator. We had addressed those as well. And we're here this evening seeking approval for these minor modifications. We did work diligently on the original approval with all the surrounding landscaping. None of that is changing.
Okay. Art?
Well, there's a checklist in my notes regarding simply ministerial matters that need to be considered as part of the public hearing. Chris has already dealt with the matter of compliance with notice and posting requirements. That's been met. I assume the CEO has issued no new review comments. He issued comments back, I think, on November 14th.
November 13th.
Those were responded to by Jason.
I haven't seen anything additional,
No,
have you?
and, some of the comments that were made just couldn't be responded to or couldn't be addressed because of the constraints imposed by the special permit back in 1987 in terms of building separation, et cetera. So there don't appear to be any issues there. Have there been any comments from the planning board engineer?
I haven't seen any.
No. And there really are no engineering changes on that?
It's minor in nature.
Right, okay. Conservation Advisory Report, Waterfront Advisory Report, County Planning, I know said local concern, matter of local concern, meaning there is no matter of county interest involved. So we're looking for the CAB report, the Waterfront report, and the report of field visit.
Okay.
And then any public comment.
All right, you want to start with the field visit? That was Woody and Sharon?
Woody and I, actually.
Oh, okay,
Jesse and I,
okay.
go ahead.
Yeah, we took a look around the site. Everything's pretty minor. The deck, the swap out of the buildings doesn't seem like a major deal. And the deck seems like a nice add. Getting rid of the refuse areas, I think, is a great idea. I think it's going to work for them.
Yeah, my perspective, everything you're proposing is the right thing to do. Simply as that.
Okay. Ryan? Ryan, do you have any comments?
We have one comment.
Okay, come on up. And is this Conservation Advisory or Waterfront?
Conservation.
Okay.
Hi, Robert Donaldson, Conservation Advisory Board. We just have one question, and I'm going to address it to you. I mean, on your map here, what are the bio areas that are designated?
These are the bioretention areas for management of the stormwater. We worked with the Conservation Advisory Committee last time for the approval for all the vegetation that's been placed within these. We've made no modifications to the vegetation.
Thank you. That's our only concern with it.
Okay, and is there any report from the Waterfront Advisory Committee?
Our report will be submitted at the following of this week. We had some member issues, but we will have a report where we're ready to be submitted.
Well, we're at the point of draft report, right?
Did they receive it 30 days ago? That's
How long ago did you receive it, Ryan?
From our last meeting
no.
of
The referral.
this board in January.
The referral.
The new documents, I received them before the January meeting.
So it's more than 30 days.
The operative provision here essentially is that the Waterfront Committee or the CAB in either case has 30 days in which to respond. If they don't respond, if the bodies don't respond in that period, the planning board is free to act without a response.
Okay.
If, however, 30 days have not expired, then the planning board is constrained from acting. If 30 days have not passed.
Oh, great. Okay, all right, so we're all right. All right. All right, let's open it up to the public. Is there anyone here that would like to speak on this project? Brennan, did you get that information from us?
Just that one.
Okay, but that came in, I believe, after the, all right. No, it appears to be no public comment. All right, so Art, do we need a motion to close the public hearing?
You can move to close the public hearing because you took a secret position on this previously, which was basically that it's this particular modification maintains the consistency of the project with the project as previously reviewed under seeker.
Okay.
Which means you can then close the public hearing and you could move forward on a resolution of approval or conditional approval.
Well, we have a motion to close the public hearing?
So moved.
Second?
Second.
All those in favor?
Aye.
Opposed? Abstentions? All right, should I go ahead with the draft approval resolution, or do you want to wait on that?
You can move on that, and in light of the absence of comments, not unexpected from the planning board engineer, you could delete the A paragraph under 3.
Okay. So do I need to read the whole thing, or you can direct me as to what I must read? This is not that long, so let me, till we get our act together on this, let me read the draft approval resolution. Pursuant to special use permit granted by the Town of Rhinebeck ZBA on February 10, 1987, the Town of Rhinebeck Planning Board hereby acts as follows. In the matter of the December 15, 2014 application by Rhinebeck Gardens Group LLC for site plan review and approval, amendment of site plan approval granted on September 19, 2011 for Phase 3 of the Gardens at Rhinebeck Residential Development on Gardens Way between Astor Drive and New York State Route 308 within the Rural Agricultural District in the local waterfront revitalization area. All is depicted on the site plan prepared by Chazen Engineering, Land Surveying, and Landscape Architecture Company, P.C., dated January 31, 2011, and revised to December 15, 2014, and otherwise the subject of supporting information, including the narrative description of proposed modifications as set forth in Chazen's letter to the Board of November 3, 2014, in the required coastal assessment form. 1. Reaffirms as determined on January 5, 2015, the proposed modifications in the Phase 3 site layout and development components plan do not substantially modify the overall project, for which a negative declaration under seeker was issued by the Planning Board on September 19, 2011, and thus deems the proposed modifications consistent with said negative declaration and absent either substantial product modifications, changes in circumstance, or introduction of additional involved permitting or approval agencies requiring no further environmental quality review. 2, further deems modified Phase 3 to be consistent with pertinent coastal policies as set forth in the town's LWRP. 3, approves the application for site plan review and approval, amendment of site plan approval granted on September 19, 2011, and authorizes the chair to stamp and sign the site plan and the clerk to provide copies thereof to the applicant, the zoning enforcement officer, and the building inspector upon the applicant's satisfaction of each of the below conditions and/or requirements within the next 6 calendar months of the planning board's adoption of this resolution. And now A becomes, A is submission of the site plan drawing in required form and number. B, payment of any outstanding fees or reimbursable amounts due the Town of Rhinebeck with respect to the submission, review, and processing of this application under Town Code Chapter 125 Zoning and Seeker as set forth within the town's fee schedule and executed escrow agreement. In taking this action, the Planning Board further authorizes the zoning enforcement officer to issue a certificate of occupancy for each of the proposed 92 dwelling units within Phase 3 upon his determination the approved site plan has been carried out and all applicable codes, laws, rules, or regulations within the purview of the CEO and/or building inspector, including but not limited to the requirements of the New York State Uniform Building, Construction, and Fire Prevention Code, have been satisfied. Could I have a motion?
So moved.
Second.
Second? I need to poll the board? I'll poll the board. Sharon?
Aye.
Woody?
Aye.
Jesse?
Aye.
Eric?
Aye.
And I'll vote aye. Thank you. All right. I have lots of copies. I just need to find them. No? Well, I thought I had lots of copies.
We can give Richard.
We'll make sure that you get one. Brandon, will you get it to him tomorrow?
Thank you very much.
Okay. Yes.
You know, you gotta give us a little bit of allowance. We had trouble getting on our driveway, not just to say, there were issues. I sent a letter, thanks to the great help of Brennan, and I've got copies of it, but there were issues that are outstanding which came up in earlier hearings on this project and have been failed in the plans for Phase 3, specifically lighting. There was a strong discussion to minimize light pollution. They're going to have 47 17.5-foot light stanchions in the plans for Phase 3. That's not what this commission discussed earlier. That's important. Second, landscape buffer. You can see what in the letter that I sent. There's a letter here. You can see if you need-
Sir, I'm afraid that we've closed the public hearing, and we've acted on this application. The public hearing began at 6:35. And I'm sorry, but the proceeding is closed.
Did you not get my letter before
We
6:35?
did not, we got your letter at 6:30, and
Was it included in the public
it
hearing?
was not because those materials need to be before noon.
This is a powerful firm against the voice of River Road neighbors who only pay their taxes and own their property and do their individual. And we're getting steamrolling with the cooperation of the planning board.
No, I would disagree that you have the cooperation of the planning board.
No,
We fi-
they have the cooperation of the planning board. I'm exactly right.
Well, as we went through when we were reviewing our checklist of things that we needed approvals for, a number of entities have reviewed this proposal. We took action. There was no public comment. Not one other person was here to comment on this application. So I'm very sorry that you were not here in a timely fashion, but
Our paper said 6:45, not 35.
Our papers were here, and this is not a wild claim, it's a substantive claim. In the minutes of this planning board is discussion and the requirement to minimize light pollution in successive phase 2 and phase 3. There are photographs in the email that I sent to you, and there are 47 17.5-foot light stanchions within the boundaries of phase 3. That doesn't seem to make sense by any standard, and should be considered by this planning board.
okay. Thank you for your comments. We're going to move on now to our next public hearing for this evening. Is there anything else I should do on that? No. All right, this evening, it's conduct of a public hearing on an application for subdivision plat approval in the matter of proposed consolidation of two separate tax parcels, and they're listed in the rural countryside RC5 district into a 27.6 acre lot for construction of a single-family dwelling, being a minor subdivision lot consolidation and an unlisted action under seeker. Nadine?
Hi, I'm Nadine Carney with Peak Engineering, and Jeremy Colson will be making the presentation today.
Green cards, vote?
Sure.
Good
Okay,
evening, Madam
good
Chairman,
evening.
and members of the Planning Board. My name is Jeremy Kozin. I'm an attorney with the law firm of Zarin and Steinmetz, here representing Stephen Hull, the owner of the subject parcels located on Round Lake Road, opposite the Beecham Road intersection. We're here, as you likely know, for a lot consolidation of two lots pursuant to Town Code Chapter 101-4.4. One is a 26.7 acre larger lot. The other is a smaller 0.88 acre lot. Essentially, what we're looking to have approved is a single lot, which would be 27.6 acres. I believe we were before your board at the January meeting. Unfortunately, I was not here. Partner at our firm, I believe, adeptly conveyed some of our primary points. Since that time, a site visit, I believe, was conducted. We've provided the notices to Brennan and to the town. And I believe the Town Conservation Advisory Board today, or we received it today, issued, they find no issue with the application. Nadine and I are here to answer any questions should your board or any members of the public have. It's a simple two-lot consolidation into one lot, and hopefully your board will close the public hearing, finalize the environmental review, and grant the lot consolidation approval.
Okay, thank you. Again, as in the last application, we have a list of information that we need to address. We've received all the compliance with notice and posting, so we're all good on that. Art, do you want to talk about the driveway?
Previously, when this matter was before the board, one of the directives of the procedural resolution was to request town highway superintendent's review of the driveway access. Well, in fact, this particular parcel is not located on a town highway. It's in fact on Round
Lake Road.
And Round Lake Road is a county highway. It's an existing driveway cut. There's no jurisdiction for the town highway superintendent, and because it's an existing cut, there's no need at this point in time, as part of the planning board's process, for review of the driveway access point by county DPW. It is possible, as I believe we communicated a couple of days ago, that the code enforcement officer, at the time of issuance of a building permit, could ask for a review of the access point by county DPW, but it's not germane to the planning board process here. So that's the situation there, and beyond that, there are only two reports that should be in the record. One is the report of the CAB, which has been referred to and needs to be presented to the board. And the second, of course, is the report of the board's field visit.
Okay. As it turns out, I was the only representative of the planning board to be able to attend that visit, but Ryan was there with me as well as Lisa Camp. You want to come up, Ryan, and perhaps share your observations?
Good evening, Board. Chair of the CAB, Ryan Dowden. I was present along with CAB member Lisa Camp for this site visit out on Round Lake Road, and being that it is a lot line consolidation, we felt the project had no issues, and we felt that when the project is completed, it'll be a very nice site for the homeowner. Thank you.
I would concur. It's a beautiful, beautiful piece of land up there. I think the project should work out very well. I didn't see any concerns with it. I share Ryan's opinion.
Thank you.
All right, we'll open it up for public comment. For those of you who just came in, we're speaking on the Stephen Hull Round Lake Road project. Any members of the public? No members of the public here. All right. We're looking at the possibility of considering the seeker. Did you have some comment?
No, I just wanted to, if there was no public comment, come back up.
All right, Art, what comes next?
You've got a draft seeker resolution. It's a simple resolution reviewed on your behalf in the short EAF, and identified, obviously, as the CAB has pointed out here, no impacts associated with this proposal.
Should I do this before closing the public hearing?
You have to do the secret determination before closing the public hearing.
Okay, let me go ahead with the draft seeker resolution. The Town of Rhinebeck Planning Board hereby acts as follows on a proposed action involving a December 10, 2014 application by Stephen Hull for subdivision plat approval in the matter of the proposed consolidation of two separate tax parcels, and the numbers are listed, on Round Lake Road, County Route 52, opposite the Beecham Road intersection in the Rural Countryside District. All is depicted on a survey map entitled Lot Line Alteration Lands of Stephen Hull, prepared by Decker Surveying and dated December 22, 2014, and otherwise described in the application and supporting documents, including short EAF Part 1 and property deed. The proposed action, having been classified by the plant, proposed action having been classified by the planning board as an unlisted action under seeker, for which coordinated environmental quality review with other involved agencies neither is required nor has been undertaken. 1, determines upon review of the EAF Part 1 and its own completion of the annexed EAF Part 2, in consideration of both field observations and the criteria for determining significance set forth at Title 6, Part 617.7C NYCRR, the proposed action, as described in the application and being an unlisted action, will cause no potential significant adverse impact on the environment, and thus issues a negative declaration deeming an environmental impact statement to not be required and stating such will not be prepared. 2, authorizes the chairman to so execute the short EAF and directs the planning board clerk to file the short EAF with negative declaration annotation in the manner set forth within the seeker implementing regulations, Title 6, Part 617.12, NYCRR. Can I have a motion?
So moved.
Second.
All those in favor?
Aye.
Opposed? Abstentions? So we only have the 2 public hearings? We only have the 2.
You have an approval resolution.
I know, but normally we would delay that, but I'll go ahead with that. So we now have before us a draft approval resolution.
Close the hearing.
Motion to close the public hearing.
So moved.
Second?
Second.
All right, now moving on to the approval resolution. Town of Rhinebeck Planning Board hereby acts as follows in the matter of the December 10, 2014 application by Stephen Hull for subdivision plat approval in the manner of the proposed consolidation. This whole first paragraph is exactly the same paragraph that I read before,
Except for the last sentence.
except for the last sentence, which is
And being the subject
and
of.
being the subject of a negative declaration determination of non-significance heretofore issued by the planning board. Approves the application for subdivision plat approval and authorizes the chair to stamp and sign the subdivision plat for the Stephen Hull Minor subdivision and the clerk to provide copies thereof to the applicant and the town assessor upon the applicant's satisfaction of each of the below conditions and/or requirements within 180 calendar days of the planning board's adoption of this resolution. 1, stamping of the subdivision plat as an approved realty subdivision or either as a non-jurisdictional subdivision or for filing purposes only by the Dutchess County Health Department. 2, submission of subdivision plat drawings in the number and form specified within the Town Code Chapter 101, including thereon all required stamps, seals, and certifications. 3, payment of other outstanding fees or reimbursable amounts due the Town of Rhinebeck with respect to the submission, review, and processing of this application under Town Code Chapter 101, subdivision of land in seeker, as set forth within the associated town fee schedule and related escrow agreement. 4, in consideration of the planning board's determination that no new building lots or sites are be created, deems not applicable to this application requirement for either the set-aside of parkland within the whole minor subdivision or payment of a cash in lieu of land recreation fee to the town of Rhinebeck for deposit in the town's recreation trust fund. A motion? Second?
Second.
And I'll poll the board. Chair?
Aye.
Woody?
Aye.
Eric?
Aye.
Jesse? And I'll vote aye. Okay.
Thank you very much.
Thank you. Have a good evening. All right, do you want to explain this at this point, what we've decided, because Jennifer's come in, so.
Okay. Yeah, I guess there's some folks who weren't here at the beginning. Earlier in this meeting, the planning board accepted the applicant's request that the continuation of public hearing on Astor Courts be deferred from this evening and rescheduled to a later date. The board did take an action to reschedule that, the continuation to its meeting of March 2nd at 6:35 p.m. The planning board this evening, therefore, will not be conducting the continuation of public hearing, but does intend to consider various ministerial actions with respect to the Astor Courts application, all of which were discussed at the last meeting. The first of those, and I'm going to get into this for the chair in just a moment, the first of those is to report on the results of the technical work session that was conducted and the consensus that was reached at the technical work session. The second is to identify how the applicant has, in the interim, since that technical works session, responded with revised submissions to the planning board. And thirdly, in light of the technical work session and the revised submissions, the planning board intends to entertain the potential adoption of a resolution authorizing the issuance of a seeker NOI, seeker notice of intent to serve as lead agency. So those are the three items sequentially that are under consideration this evening.
All right.
Right? You want to get into the technical?
I do. I want to get into the report.
I'm going to The board has a report kind of in writing in the meeting notes, but I'm going to cover every item that came out of the technical work session so that everyone understands, the audience and everyone else understands what was discussed and what consensus was reached. There was a technical work session as directed by the board. It occurred on January 14th. It was attended by not the vice chair, but the acting chair, Melody, the CEO, Ron, planning board engineer, Ray Jakowski, and myself. It was also attended by the applicants as well as the applicant's engineer, Mark Rominski. First item of business was the discussion of what use is really being requested, and it was absolutely confirmed by the applicant that the intended change of use is conversion from a single-family dwelling, which is what the property is today under the zoning law, to a country inn one. And the country inn one is not being proposed in tandem with or severally from a quote conference center. There is no proposal for a conference center, which would in this case have been a small-scale conference center in that particular district. So it's strictly a country inn one. Secondly, there was a review of the fundamental requirements for a country inn one, and it was agreed that there would have to be a modification in the proposal for the country inn to accommodate either within the principal dwelling or elsewhere on the property some residential accommodation for either the owner of the country inn or a caretaker for the premises. That's what the zoning law provides, either as a stated special permit condition or by definition.
Can you have both?
Yes, they could have both. There was a discussion of the permit that was issued by County DPW for the improvement that's since been completed of the access driveway intersection with River Road. I don't have it in front of me, but a copy of the permit that was issued by the county for that improvement was presented by either the applicant or the project engineer, and is now in the record. There was a discussion of the access driveway liability issue that was raised by Mr. Duffy's attorney, Jennifer Van Tile, who's seated out there this evening. And there was no discussion. I'm saying the presence of the issue was raised. And it was simply, the discussion was limited to acknowledging that the matter has been referred by the to the town land use attorney for his review and guidance as to consideration by the planning board. As of this evening, John Lyons, planning board attorney, has yet to complete his examination of that particular issue. Therefore, that is not a matter for report this evening. There was next the identification of some work that had been previously undertaken on the property without prior town approval or permit that may have been required, should have been required, including matters related to the modification of the stone wall along River Road, adjacent to the driveway access improvement, and clearing of the sloping ground between the principal dwelling and toward the riverfront, toward the railroad track. The ZEO was to take further look at those particular items and determine what, if any, additional applications, corrective, if you will, would have to be submitted to the planning board. There was acknowledgement by the applicant and the project engineer of compliance, of need to comply with speedy stormwater requirements, and Mr. Rominski is going to be developing an appropriate report to present to the planning board and for the planning board to present to Ray Jakowski, the planning board engineer, for review. There was confirmation by the applicant that there are no present plans beyond the recent clearing of vegetation within the dock area to undertake any other improvements that are related to the dock or the powerhouse that's in the vicinity of the existing riverfront dock. was a discussion of the accommodation of water supply and sanitary sewage requirements. It was confirmed that water will continue to be supplied by the Village of Rhinebeck water system, and that sanitary sewage will be accommodated on-site. Project engineer reported that the county health department has rejected the use of any sort of a pump-out tank, and that there would have to be some expansion of the existing SDS required. And obviously, the expansion of that SDS would require design approval by the county health department. There was a question raised that needs to be considered by the project architect and the town building inspector, and this kind of followed the discussion of water supply as to what the fire suppression requirements might be for the intended use. And it was conjectured that if the installation of sprinklers is required, the available water supply pressure may not be adequate to accommodate fire flow requirements. In the first instance, the existing fire flows would have to be measured, and if necessary, there would have to be a proposal for the installation of either a booster pump and/or a storage tank to meet those requirements. Was a question raised, I believe I raised it in the first instance, and it was echoed by the CEO, as to whether the maximum building height standard for a principal building in the Historic Preservation District was being exceeded by the rooftop addition. It was agreed that that question would be examined in greater detail by the CEO upon presentation of more complete building elevations. Those were the areas of discussion. Board have any questions about, or are they all fairly straightforward?
Was the building inspector involved in any of this?
No. It was left at the zoning, standpoint of zoning at this point in time, CEO.
Particularly for the fire suppression piece, because
that's the matter.
I believe that's now a multiple dwelling, and I believe it has to be sprinklered.
Yes, yes.
And also fire escape from the number 3 floor have to be considered. And that's why I would recommend that the building inspector review that code with the applicant and whomever else has.
Well, we actually at the meeting.
Yeah, those questions regarding fire suppression and fire code requirements, it was agreed that they would be addressed
by the architect.
not by the project engineer, but by the project architect with the building inspector.
Yeah.
Not with the code enforcement officer. That was
Yeah, it
part
has
of
to be building inspector.
Right.
Right. So that was a summary of the topics discussed. There have been movement in a couple of those areas that I'm aware of. One is that the CEO has, upon review of more detailed plans, identified a maximum height excess, if you will, by the proposed rooftop addition. I believe it's at 37 feet 4 inches or something of that sort, as opposed to the 35-foot requirement. So that's going to be an area where there will likely be some variance consideration. And there were certain other aspects of both the existing, principally the existing development, not the proposed development, that Ron had indicated as perhaps being ripe for consideration by the ZBA.
Correct.
That's essentially the movement that has occurred on the town side. In response to the discussion that was held, there are at least 4 items that have been forthcoming from the applicant that really are modified parts of the application package that's been submitted to date. The project narrative previously prepared was revised to January 22nd and has made much more explicit the description of the use, the fact that it is country Inn 1 only, the fact that it includes the residential accommodation, which will be a caretaker's apartment, et cetera, et cetera. So there's a revised project narrative. There's a revised site plan that was prepared by the project engineer and dated January 22nd and submitted to the board. I believe that indicated some modification in parking areas and things of that particular sort. There's a revised floor plan for the basement of the structure, the existing structure, for now proposed in the basement is in fact a caretaker's apartment, as is required under the zoning law. And an as-built plan for the entrance improvement that did occur at River Road was also submitted by the project engineer. I believe those are the new pieces. Additional building elevations were submitted. In other words, four-side exposure, and those were the matters that were reviewed by the ZEO. That's essentially the background. Where we're at this point in time, where I believe the board is at this point in time, is we now have a handle on specifically what the intended use is. And again, it's country N1 and nothing else. We have some revised documents that, including the narrative, the revised site plan, etc., that describe the project in enough detail that the planning board may, in my opinion, be in a position to issue a notice of intent to serve as lead agency under seeker. We're now in a position to be able to identify involved agencies that a month ago we were not necessarily able to identify. Two in particular, we didn't necessarily know that the health department was going to be an involved agency because there was still talk about relying on existing systems. We didn't know that the village water department is going to be either an interested or involved agency because there may be some modification required on the pressuring of the water line, etc. And we clearly did not know at that point in time that the ZBA is going to have to be an involved party with respect to area variances, one or several that may be necessary. So I think we've got a handle now on identifying who those other agencies are also. That being the case, the only thing that you have before you, which will be a prospective action item after any discussion you have, is a resolution authorizing the issuance of the NOI, including the identification of all those involved agencies, interested agencies, etc. There is attached to that resolution an actual draft of the NOI. You have an abridged version in your meeting notes. Brendan has an expanded version that has all of the addresses and things for the agencies included. And the only further question would be, it's a matter of providing, I think, to all the agencies as much information as possible, which basically would be a full package of the information that's been submitted to date. I believe that can occur through either a hard copy or an electronic format. If it were to occur which basically the bottom line is you could provide a hard copy of the NOI and a disk, including the rest of the documents, as for instance.
Art? It's not a public hearing.
Well, I believe it is an adjourned public hearing, and since it is an adjourned public hearing, I think that people should have an opportunity to speak, and I would like to speak on the very point of whether this is ready to circulate to the agency. I promise to be brief.
It's not been done before, Jennifer, so you're asking.
Well, is it not an adjourned public hearing if it's noticed?
The continuation was, by earlier action this evening, the board deferred the continuation of this hearing to March 2nd at 6:35.
Right. May I speak to the point of whether the action should be subjected to a lead agency notice, that procedural point?
You know, the request was made at the request of the applicant because their representatives could not be here this evening. So, you know, I'm struggling with how to be fair when those people who are representing them are not here. That's my difficulty.
Right, and I don't want to say anything that's unfair. The applicant is certainly here to listen to what I have to say. I think that it is the zoning enforcement officer whose role it is to make a determination of what the use is. We have reviewed the amended plans and have great fears that this application is more than it appears to be. We find the narrative to be very non-disclosing of what the use is, and I believe it's therefore very premature to circulate for lead agency, absent a determination by the zoning enforcement officer that this is indeed a country in one use, because I'm happy to speak to the point. If you won't let me speak, I
think you have.
but I have
Ron, part of the
documentation to
session.
show related to the maps concerning that, and I think it is unfair and inappropriate to circulate for the agency on proposed action before the zoning administrator, the zoning enforcement officer has made that determination.
Well, let me, I mean, I don't know that you heard it, but the zoning
I'm happy
enforcement...
to explain why I think
The zoning enforcement officer was a participant in all of the technical meeting that we conducted. So his opinions were freely offered and accepted. And I don't know what more to say.
I made sure at that particular session, everyone said, well, where do we begin? And I said, we have to have a firm discussion of one particular item before we even move to any additional discussion. We have to discuss what the particular use is vis-a-vis the use table, the district schedule of use regulations, based upon the special permit standards that relate to those given uses, and based upon the definition of country inn. And we have to recognize that this whole discussion, that there's been some confusion because the prior application was in fact not for a country inn, it was for a conference center. I think we probably spent at least a half hour discussing that particular item. The applicant and everyone else was in agreement that with the modification to include the caretaker's apartment, that we were now dealing with a country inn one, that there would be no major conferences, there would be no weddings, no other special events held at this facility. That would it would go beyond the occupants of, you can correct me if I'm incorrect, the occupants of 12 guest rooms may be sitting around at a breakfast table discussing some issue or something of that sort.
the plans clearly show bathroom facilities that would accommodate 750 people on the site. The so-called caretaker's apartment is 450 square feet, substantially smaller than the wine cellar. It is not a residential accommodation. The tennis court could easily be refloored to accommodate untold numbers of people for events, and the guest dining room facility is large enough for that too. And there is no commitment in this narrative that there will not be conferences. There's no commitment that there will not be large banquets or gatherings. And I think that it is the zoning enforcement officer that has to make that determination. And I think the record is very unclear. And I don't think it's clear that the zoning enforcement officer has acted. We believe that there's a substantial record to support an inference that this may actually be something proposing uses that are only permitted in a conference, the country inn too, which is a prohibited use in this district. And that we can't really have uses where people are in private meetings making representations about what their uses are. There has to be a documented record of a narrative and an interpretation by the zoning enforcement officer to have anything for the town to stand on in future years when this property is sold and occupied for other uses.
Oh, no. Let me...
I would just ask that that circulation of the meeting is deferred until this public meeting can be properly continued to allow comment, or until the zoning enforcement officer has actually issued the zoning compliance decision, on which I've asked for the opportunity to comment.
I don't know, I'm looking through here. No, I don't.
Ron, do you have a copy, Brenda? Do you have a copy of Ron's memo spelling out the variance requirements? And does he begin that memo by referring to the country inn one?
Here, this is the one you're... I think I have it, Brendan. I think so.
Yeah, he doesn't. He doesn't say what he has concluded that it is a country inn. He moves on to the
variances.
He moves on to the details.
Mm-hmm. Well, let me open it up for questions from the board. thoughts?
I'll start.
Okay,
I think there's been more questions than there have been answers in this session, and I question whether the lead agency designation, if it's done today or next month, will have any impact on anything other than doing it right. If there's no reason why we have to do it tonight or should do it tonight, I would recommend that we hold off until after or during the public hearing system.
Sharon?
I think I agree with Woody.
Bessie?
also do.
Yeah, I agree.
All right, there seems to be,
Yeah, you're going to ask, basically you're asking Ron to confirm, to make a zoning determination, to confirm what he already said, what he basically says in an opening line of this letter. I just concluded a meeting with project engineer Mark Rominski, representing Astor Courts Country N1 project. Ron has been talking about this as the Country N1 project since the technical session.
Excuse me, under Country One, is there a strict occupancy level?
there is only 12 rooms.
No more than 12 guest rooms.
But occupied by how many people? Does that assume that there's 2 per room or possibly 3?
Doesn't make that
It
assumption.
doesn't- The zoning ordinance does not say.
Does not say, but 12 rooms.
Okay. 12 guest rooms.
Well, I'm hearing
Yeah.
the consensus of the board that there be no action taken this evening, that we come back at the March meeting and take this up again as part of the public hearing.
Yeah, I believe we need a firm document that says from the zoning enforcement officer what his position is. That's ironclad one way or the other, so we understand it.
Okay. Everybody in agreement? Okay.
Resolve some of those other issues too that he has raised.
Right. All right, I think that
Okay.
would conclude our discussion of this project. Yes, ma'am.
It's being postponed. How many more public, how do you decide on how many public hearings there will be?
As many as are needed.
So the public is given an opportunity to complete its viewpoints. If they don't complete it at the next meeting, then it will go on to the next month. Is that what will happen?
Let me give you my impression. As long as there are new issues being raised that have not been resolved, either by planning consultants or by our own engineering consultants town, we'll continue to hear the issues. It's-
All these other things that is now here, are they separate public hearings? You have variances and other things that have to be listed?
Variances will go to the zoning board of appeals. And I believe some variances have, is that coming before? Been discussed, but they're not yet formally before the zoning board of appeals. They will go through that process before they come back to us.
And this is a type 1 action under seeker before the ZBA too, so the ZBA will not be able to act on any of the variances until the planning board, if the planning board is ultimately deemed to be the lead agency, the ZBA will not be able to act until the planning board. So this has got months to run, because deferring the seeker circulation right now means the seeker circulation wouldn't occur until March at the earliest. The planning board can't be lead agency until sometime in April.
Right.
You know, et cetera, et
It's got the
cetera.
30 days.
Right.
Right. And
I was prepared to speak with Mr. Cassidy today, and I will not be here. And I can't do something.
the public is always able to submit anything in writing. You also have the opportunity to present your remarks before the Zoning Board of Appeals when it meets on variances. So I guess I would assure you that there will be multiple opportunities, in my opinion, to make public comment about this project, either at the Zoning Board of Appeals or back before the Planning Board. Am I correct in that? Okay. Anybody else, since nobody's talking but everybody is? Anybody else want to have their say? All right. Thank you all for coming and participating. All right, that concludes the public hearing part of the public, non-public part of our meeting, and we'll move now into our regular session new business. Not running too far behind. All right, before us, first this evening is...
I'm going to just submit this letter with copies for
Sure.
everybody tonight. Is that okay? Can you just
Absolutely.
let us know? Thank you.
Thank you for adjourning the meeting last night. I was like on pins and needles with the snow.
Tried to do it early enough. You know, you hate doing it. You just...
I know, and it was smart to do it.
All right, first up, Edmund and Arlene Pasquarelli, 29 Delano Drive, subdivision. In consideration of the area variances granted both the applicant and abutting owner, Joseph Romeo, on December 17, 2014, in the manner of non-complying lot area, initial presentation of application for subdivision plat approval for reduction of tax map parcel numbers listed from 2.610 acres to 2.492 acres, with the other 0.118 acre to be transferred to and merged with land of Joseph Romeo, all located within the rural countryside district. Planning board review for completeness and processing as may be timely under Town Code Chapter 101, subdivision of land and seeker. Good evening.
Good evening.
You want to introduce yourself and tell us about your
My name is Michael Viteri. I'm a licensed land surveyor representing Joseph Romeo and Edmund and Arlene Pasquarelli. We were here before the board in November, and we were referred to the Zoning Board of Appeals for various issues, including area variance, side yard variance, a rear yard variance, and a construction of an earthen berm within 100 foot of a stream. And I believe all these variances were granted by the Zoning Board of Appeals. So we're here tonight to get the planning board's approval of this proposed lot line change and increase in size of the lots of Romeos to accommodate a pool and proposed pavilion, which a building permit was issued prior to finding out what the actual property line was.
Right. So there's a little bit of corrective action going on here.
The cart before the horse in this instance. So what we have is a lot line revision in which the Romeo lot will be increased from 2.403 acres to 2.521 acres, and the Pasquarelli lot will be decreased from 2.610 to 2.492. They're both in the R5 zone, which required an area variance.
Right.
Because they were deficient.
And remain deficient. Okay. I think the only administrative issue that we had before us was that we needed to clean up a written statement by the Pasquarellis authorizing Romeo's to make the application. Is that correct?
Okay.
Is that?
Authorizing Mr. Viteri to act on their behalf.
Okay, okay, all right. And that has been received.
And Romeo to submit on behalf of Pasquarelli. Because the subdivision application was submitted by Mr. Romeo.
Right.
I'm afraid that all we discussed was having the authorization for you to act on their behalf, which we had in the ZBA file, and I think I sent to you guys.
Is he acting on behalf of both?
Yeah, acting on behalf of both.
That's good enough. But
That's good enough?
yeah.
Okay.
But the underlying issue is that Mr. Romeo submitted the application to subdivide
Mr. Pasquarelli's land. That's a no-starter. Or we'd all be trying it.
You've got a draft resolution.
Got a few eggs.
All right, I have a draft procedural resolution. Any questions or concerns on the part of the board?
No.
All right, let me go ahead with this draft procedural resolution. Town of Rhinebeck Planning Board hereby acts as follows. In the matter of the October 31, 2014 application by Joseph Romeo, as represented by Michael Viteri, and as agent for Edmund and Arlene Pasquarelli for subdivision plat approval for reduction of tax map parcel at 29 Delano Drive from 2.610 acres to 2.492 acres, with the other 0.118 acre to be transferred to and merged with tax map parcel, whatever, at 13 Delano Drive, land of Joseph Romeo, both within the rural countryside RC5 district. All is depicted on a survey map entitled Lot Line Revision, Joseph Romeo and Edmund and Arlene Pasquarelli, prepared by Mr. Viteri and dated September 9, 2014, and otherwise described in the application and supporting documents, including a short EAF Part 1 affirmed by Mr. Viteri and an agricultural data statement completed by Mr. Romeo. 1, acknowledges the ZBA granted area variances to abutting owners Edmund and Arlene Pasquarelli and Joseph Romeo on December 17, 2014, in the matter of non-complying lot area, which action permits the planning board to proceed at this time with consolidation of the above-cited application for subdivision plat approval and could, if approved and implemented, permit the planning board to consider certain applications under Town Code Chapter 125 zoning submitted by Mr. Romeo related to improvements he either has or proposes to undertake. 2, accepts the application as adequate for review by the planning board, the board's advisors, and the public. 3, classifies as the subdivision as a minor subdivision lot line alteration under Town Code Chapter 101, subdivision of land being the subject of a land development technique permitted by right within the RC5 district under Town Code Chapter 125 zoning. 4, classifies as the proposed action as an unlisted action under seeker for which coordinated environmental quality review is not required and will not be conducted. 5, schedules a public hearing on the application for Monday, March 2nd, 2015 at 6:45 p.m. and directs the clerk to undertake or otherwise cause the noticing and posting thereof in accordance with the requirements set forth within Town Code Chapter 101, Subdivision of Land, Section 101-4.4. Further directs the clerk to distribute the agricultural data statement in accordance with the requirements of Sections 303 and 304 of the New York State Agricultural Markets Law. 7, delegates planning board members, Eric and Jesse, to conduct a field visit to the subdivision site and report their observations at the time of the public hearing. In accordance with Town Code Chapter 9, Conservation Advisory Board refers the application to the town CAB for review and comment. Requests further technical review of the application by the town's planning consultant and without prejudice to information that may be presented at the public hearing or may arise on the basis of the above-cited referrals and field visit, authorizes the planning consultant to prepare the working draft of an approved resolution for consideration by the planning board when and if timely. And there's a notice of public hearing, the annexed document. Could I hear a motion to accept this resolution?
So moved.
Move, second by Eric. All those in favor?
Aye.
Opposed? Abstentions? And if you want to share your contact information with Jesse and Eric, they'll be in touch with you. Will you be the person that we schedule the site visit with? Sure. Okay, and then Ryan, you'll be in touch with these guys? Do you have some? Okay, anything else with that?
I can email everybody tomorrow morning if you want. Would you like?
Oh, that'd
right.
be awesome.
I have Mr. Vitteri's contact.
Then we got a new system in place, and it sounds good to me. All right, so thank you very much, and we'll see you in March.
Great. Is there anything that I should, since I'm kind of new to this board, is there anything that I should have with me for the March 2nd meeting?
Generally, can't think of anything other than what you already have.
Could I ask a quick question, just because I'm new here, what's the purpose for this little swap?
To accommodate a pool house and a proposed planting berm, which is 80% constructed at this point. The property line was not determined before the construction began.
So we have amicable neighbors who are working to resolve this situation with a little bit of land swapping, so that they can, I guess, both go ahead.
Yeah, and once the land swap has been approved by once the annexation, the subdivision has been approved by this board and the annexation of those additional lands to Mr. Romeo occur, then Mr. Romeo can pursue with the planning board certain applications that he requires to secure approval for the work that's 80% done.
80% done. So sometimes...
Some of which involve variances from the ZBA and some of which involves site plan and special permit from this board.
So with luck, they'll enjoy the pool sometime in the summer if things go according to plan. I think you're fine. Thank you very much. Okay. Second item under new business this evening. Catherine Whitman Architecture on behalf of Dunya, is it Dunya? Dunya van Stoddard, 362 Rhinecliff Road, special use permit, site plan and wetlands permit. This is a sketch plan conference and initial presentation of applications for special use permit, home occupation, site plan review and approval, and wetlands permit in the matter of proposed conversion of existing garage to an art studio, construction of a new garage, and related site improvements on tax map parcel within the rural agricultural RA10 district. Planning board review for completeness and processing as may be timely under Town Code Chapters 120, Wetlands, and 125 zoning, and seeker.
Just one addition to that, as pointed out in my notes, subsequent to this item hitting the agenda, the CEO has ruled that this particular project requires either 5 or 6 area variances. Therefore, the matter of completeness and processing of the application will probably not occur this evening in accordance with the board's policy. You can, however, and will, however, be having the required sketch plan conference.
So it's the time you get to ask questions. Catherine gets to tell us as much about the project as she can possibly tell us, and then the applications for variances will go ahead. They've all been received, Brennan? These have been received?
Yep.
Okay. Thank you.
They'll be hopefully accepted tomorrow.
Okay, so hopefully they will be accepted at tomorrow night's ZBA meeting. Okay, great.
And for your information, Eric, the board policy will move sometimes in tandem with the ZBA, withholding action, not the ZBA action. The planning board does not the applications have already been accepted by the ZBA.
And to save you money, we actually like small. Not opposed to small.
No, okay.
We have different ones, don't we?
There's 3 sheets, I believe.
Oh,
So that,
maybe you're the only one with 3. Oh, they've got 3. Okay, whatever.
There's only 2 sets.
oh, this is
So you'll have to-
engineer.
Oh, we have to share?
Yes.
Okay.
I know.
Yeah, it's most common.
Huh? That's all right, we can see from here, and I have seen it in small form, so
I've seen it in small.
we're okay. Go ahead.
So this is a property with a small road frontage on Rhinecliff Road and a long driveway that comes back.
I'd like to see Rhinecliff Road on here. I don't see Rhinecliff Road.
Commercial. This is a bus company and concessions. And then right here is the Rhinebeck Historic Society land. And this is the property. And then this is 106-acre farmland, I believe not in use. Look at this.
Oh, it's good house there.
So this property stands alone as a residence that's in that area.
For your information, I believe that farmland is considered active farmland.
Yes.
And all those cows that poop on it work there.
Yeah, they come and go, but
Well, he moves them around for various farming reasons, but
some of them leave
it's
permanently.
a very active farm.
Oh, I see.
One of the few active ones.
Right, okay. Anybody else need to see it?
On this property is a large pond that is designated as a federal wetlands. And there's a dotted section which shows the 100-foot buffer for the pond and the small stream. And then as well, there are setbacks shown. So you can see almost the whole lot.
All the dotted stuff.
Area. And at the bottom of the lot right here is currently a garage. The special use permit for home occupation would be to turn this garage into an art studio. The owner is a silkscreen printer, and she does make napkins, pillows, textiles of all kinds, and wants to use this to do so. So, in order to do that, there's a septic component, bringing a 1,000-gallon septic tank and pump right behind the building, and then using the existing leach field that's already there. As well, part of the plan is to build a new garage. This was originally built as a garage, so there'd be a new garage built closer to the house, and the driveway would be relocated to access the new garage. And then there's an existing shed down at this end, which we are proposing to demolish, but part of our zoning Board of Appeals application is to have more than 4 accessory structures, meaning if that shed stays, it would be approved to stay. So in the wetlands permit, we want permission to take it down, but should that removal not happen, we want permission.
I see. Oh, okay.
Where was the new garage?
It's here.
Is it attached to the house?
No, it's little.
This one.
I get it down here.
This is the house.
That's
This is the new garage. and these are
This is the old garage.
That's one being converted.
This right here is
Right,
the
but this little thing here,
Yeah,
This
yeah.
is open.
This is the house.
proposed new garage is here.
Yeah, it shows on your plan. It doesn't show on the engineer's plan.
Yeah.
Okay.
Oh, what is it?
It's this block here.
Oh, yeah, Eric's looking at this, the Senate, Dave Ryder's Senate.
This one here?
Instead.
It needs to be
The new
located.
garage doesn't show on this.
Oh, okay. So it's where?
If this were shaded out, it would be easier. This is the house.
Right,
And these are walkways, and this is the garage.
I see.
How do you get the car to the garage?
Through the living room.
In this driveway.
We're turning it.
Here.
Ah, I
Oh, okay, I got
See, this is changing the driveway coming around in here.
see. Right, right. Sorry. That's going away.
That would be the art studio.
But it's
Over.
going to be torn up and...
This is the art
Yeah,
studio.
yeah. And so the new driveway is replacing this existing driveway, which comes with it.
Yes.
Right. Okay.
No, I was just trying to figure out what...
We're so screening, we got all kinds of...
Right.
Hard to see it when it's not there.
Yeah.
Anything more, Catherine? No, okay. Questions from the board?
Yeah, I'm a little concerned about the home industry with this, the silk screening,
Uh-huh.
because silk screening uses chemicals, and there has to be some sort of a plan for all those chemicals, how they're used, where they're stored, and how they're disposed of.
Okay.
Is there also an issue with VOCs and that sort in the use of the...
And because that's near the Hudson River, it may create more problems, because there's an active waterway, as I recall, it goes down through there and goes across the road and eventually goes down into the river.
Okay. Well, you show a stream on here?
What the project engineer showed is a 1,000-gallon septic tank with a 1,000-gallon pump tank. That may be the manner in which he's addressing that particular manner. I don't see an engineering report that describes that.
There is an engineering report with the application.
Does he specifically address the use of chemicals? I'm sorry.
He had asked her what she was using, and she said everything is natural. I don't know all the terminology,
That has
but
to be
I
documented.
can get the...
Yes.
What's interesting, Catherine, is he's using a pump tank instead of a leach field, which infers that there might be something there that's less than desirable.
Well, I think
got a
they're
septic tank.
pumping it up to the existing leach
He's
field.
going to pump up to the existing?
And then
Well,
it'll
it looks like they're tied together.
Okay, he's tying up, okay.
So it's an uphill to the leach.
It's an uphill pump then, okay.
Same thing I have in
Oh.
Yeah, I didn't catch this line, because I looked at the small scale drawing.
Well, should,
Now, Dave Ryder should be well aware of those sorts of requirements. He was, or maybe still is, the engineer for the New York water supply at Shokan Reservoir.
well, if I'm hearing Woody correctly, we'd like some verification from the applicant, from the engineer, whoever, as to what the materials will be used, how they're going to be handled. And Woody, you were suggesting storage is also an issue?
Potentially it could be. You know, while you're going that much into it, you might just as well do the whole cycle.
Right.
You know, delivery through getting rid of the waste.
Okay.
And all the processes in between.
And ventilation requirements during the use of those chemicals.
Other comments?
Is Dutchess County reviewing this now? Is Dutchess County looking at this now, like the tie-in?
Art?
Number of submission items. We discussed Catherine discussed the wetland, the pond essentially being the wetland, which gives the wetland, I believe, a fairly well-defined boundary.
Correct.
But the town wetlands law does require, unless it's waived by the planning board, a delineation of any wetland within 1 year of the application.
We're not in the habit of...
Because of the nature of the pond, is the planning board in a position to be willing to waive the requirement for a field delineation? Otherwise, the wetlands application is not complete, because the wetlands application does require a field delineation, which has been conducted within 1 year of the date of the application.
It's considered a federal wetland because it drains into the Hudson? Is that why it's a federal wetland?
The federal wetland is based upon the criteria of hydrology, soils, vegetation, et cetera, and it's bigger than a water puddle.
Well, we can't accept this evening because of the variances.
Yeah, but we're looking at the matter of completeness of the app,
Well, no,
when you get to that point.
But my point was going to be, I'm not sure I'd want to make a decision about whether we wanted to waive it or not until we got all this information back on the materials being used, the chemicals. I mean, if it's going to have the potential for impacting this area in any way, shape, or form, I'd like to know that before we...
You'd want to know if the wetland maybe extends beyond the boundary of the pond, et cetera.
Yeah.
Okay, so number one is the fact that technically, as submitted, the wetlands application is not complete because of the delineation requirement.
Yes.
Number two, it has been mentioned this evening that the adjacent land is within a certified agricultural district and is in fact ag farmland. There has to be an agricultural data statement submitted as part of the application and then distributed. I have a question as to whether or not this site is within the local waterfront revitalization area. I believe it is. In which case...
Adam is,
There's a coastal assessment form that has to be...
Ryan's saying it is. Okay.
Okay, Ryan is confirming that it is. I assumed it was.
Coastal assessment
form has to be submitted as part of the application. Is the site, and I trust the answer is yes here too, is the site within the National Historic District? The Landmark District?
Gotta be.
In which case a full EAF and not a short EAF is required.
Are there any circumstances to waive?
No, that one definitely can't be waived. That's a requirement of DEC regulation. That's not waivable by the planning board. The other, and whether or not we were dealing with the short EAF or the full EAF, the short EAF that was submitted in response to item 2 says that there are no agency permits or approvals required. And in fact, we now know that not only is there a special permit, site plan, and wetlands permit by this board, there's Health Department SDS design and ZBA variances. So that response on the short form to item number 2 is incorrect. Would have to be changed, and it certainly is going to be changed when you move to the full EAF, where there needs to be a greater description of those applications and when they're submitted, et cetera. Now for the real, in this one I haven't viewed the property. It may sound like a silly question, but the site is within the Landmarks District. Is the frame shed a contributing structure within the Landmarks District?
We would have to go back and look.
We'd have to go back and check.
We'd have to go back and see what's
Because if the
listed.
frame shed, which is proposed for removal or demolition, is a contributing structure within the Landmarks District, approval is required under Chapter 78 of the Town Code and the zoning law for a permit to allow that removal or demolition.
Okay, so you can check on that?
So those are
Where
the,
would I thought you meant when you did the site visit, is there a...
Well, you'd have to go back to the landmark designations and find the listing for this property and determine whether any of these buildings are considered contributing structures.
Before the building could be demolished,
You have,
I think it was built in the 80s.
well, then it won't be there. Then trust me, if it's the 80s,
it won't be.
then the landmark designation precedes that, and all we need is verification that it's not considered a contributing structure.
And one more little thorn here. Does this, by some chance, does the Rhinecliff overlay drop on any part of this property? Because it's pretty close.
it's on a portion of it according to Ron, but not the development portion.
Driveway.
Is it the driveway only? I recall reading that in his review memo.
Okay, I hadn't seen that.
Yes. Yeah, it does not come under that.
It's not part of the driveway that you're moving. Okay,
Yeah.
just clarifying.
And it's not within 1,000 feet of the Hudson. Where is it?
Close. Pretty close.
It's pretty close.
Yeah.
Okay.
My gut tells me yes.
Want to check on that, Ryan?
If it's within 1,000 feet of the Hudson, it's the special permit requirement for any work within 1,000 feet of the Hudson, the stream bank of the Hudson.
Huh?
Boy, that sounds familiar.
Doesn't it?
Have you lived this before? Are you serving as special counsel?
Just helping out.
Yeah, I know.
Don't-
Ryan, when you find that out, will you let Brennan know, and she can convey that information to Catherine?
Aren't you glad you came by tonight?
Always why sketch plan is a good thing.
Yeah, those are, yeah, that's everything else.
Would any of those affect the meeting tomorrow night?
No.
Great.
No, this is information that we'll need, but I don't see it as impacting tomorrow. No.
No, because anything concerning the ZBA is dealing with a single-family use or a accessory, an authorized accessory to the single-family use being the home occupation. Therefore, from the ZBA standpoint, they're going to take the position that all of this is type 2. It's not type 2 for the planning board, but it's type 2 for the ZBA. The thing I did note, the home occupation, at least how the plan is drawn, the home occupation does occupy less than 500 square feet, which is the maximum square footage for a home occupation. I did note that there's a very, very substantial amount of storage space involved, which could or could not be, might or might not be considered to be part of the home occupation. But
it is depicted as storage.
400 square feet or something of that sort.
The lower level is mostly storage and a dark room, and then the upper level is the art studio.
Yeah, the dark room, I think, is probably in combination with the studio, part of the home occupation.
Right, so
Yeah.
that
But I think that
area
falls
is
within
added to
under 500.
of the second floor.
Okay. Other
5 feet.
questions? Eric,
A little bit over 30.
you thinking there?
Just looking.
Okay. Looking and thinking is good. Sharon, anything?
If the ZBA accepts the applications, and if all of this additional information is provided, by 2 weeks from today, the board could consider the acceptance of the applications on March 2nd.
Okay.
Yeah. That's kind of good.
At which point we could then,
Exactly.
so we won't be able to have a public hearing in March because we can't accept it as complete until.
So that would be at the public hearing in June?
No, it'd be in
April,
Hopefully in April.
hopefully in April. There shouldn't be a reason why it wouldn't be April that I can foresee at this point, but assuming everything goes as,
Well, I'll let you know as soon as
Yeah.
tomorrow.
well, and then she's the important one to let know, and she'll be there, because then her clock starts running and getting everything in 2 weeks to be on the schedule for March. Okay. Anything else from your perspective? Okay. That is it, except for 2 ZBA referrals. Thomas Kirby and Hudson Solar. Art, do you want these back, Catherine?
This one. Yeah, because I've seen the small ones, and I'd much rather work off the small.
I told her that she didn't have to spend extra money on our behalf, that we're...
Even though we're working, you don't have.
I know. More than worth
Everybody will contribute 50 cents. I'll contribute 50 cents. They will drive home to them and use
Am I missing a wheel? Oh, look at that. My cart for
That's why-
ZBA
that's
is
why it was
also
going so
missing a wheel
slowly.
downstairs.
So you take the wheel from downstairs and put it on this, and then you only have one cart that has 2 wheels.
So I guess you were paying attention.
I've got reports on the agenda, but not in my meeting notes.
Correct.
You took double things.
Want to take a minute? You want to look at them?
The Kirby,
Come on down, Ryan. You don't need to sit in the back by yourself.
the Kirby area, neither one of these area variances seem to raise any significant issues. The Kirby application is one that hopefully will soon be addressed by some sort of an amendment to the zoning law. The zoning law has a provision regarding accessory structures that basically says that you can have an accessory structure within 20 feet of the lot line. However, the zoning law also has within the area and bulk schedule, it makes no distinction between accessory structures and principal buildings. Therefore, it assigns a minimum setback in the RC5 district for any structure of 50 feet. ZEO has interpreted the 50-foot requirement to supersede the 20-foot exception. And one could argue that he's correct in doing that. One could also argue he's incorrect in doing that, but that's been the position taken. Therefore, this gentleman, Mr. Kirby, has been directed to the ZBA and has filed an application to the ZBA for a variance to allow the small prefabricated barn shed to be 20 feet from the lot line.
How big is the building, do you?
It's,
I believe it's 12 by 24.
yeah, it's something like that. It's, yeah, 12 by
One of the
24.
prefabricated Amish sheds from, guy on 199.
Yeah.
So it looks in this,
Because if it was small, I'd tell them put a set of wheels on it, and see, then it's not permanent, and that's the end of it.
isn't it 11
Yeah,
something?
it's actually 12 by 16.
12 by 16.
Oh, excuse me.
There's one of those in Rhinebeck right now that I know of.
It's 12 by 16, Woody.
Oh, that's still too big.
Even
Can't put
better
wheels
for
on that.
wheels.
Can't go down the highway, so it can't have wheels.
There's a picture of it here in this cut.
Oh, okay.
So that's the issue there, and I don't think there's any,
No concern, what?
planning board has, I think planning board adopted a very simple position, it has no planning or environmental concern with respect to that application.
You want a motion?
Motion.
Could I have a motion that the planning, there.
Second.
All those in favor? Opposed? Abstentions?
Yeah, it's not, there's nothing here to even mention, sometimes the board adds further things about the extent of the variance, things of that sort, but not here. Next one.
Hudson Solar?
No accessory structures allowed in the front yard, is what the zoning law says. Proposed solar collector's installation. There have been similar applications recently for the location of a generator in the front yard. The position of the zoning law is no accessory structures of any type within a front yard. This particular applicant is asked for a variance to allow solar collectors within the front yard on a property on Agriculture Road.
I think the town's really ought to go back and revisit that whole solar collection thing because they're pushing solar, but yet,
Right.
I mean, some of them are ugly, I'll grant you that. I mean, I know one in particular. that
Yes,
I
we
think is
do.
ugly and it's there. It's been there for a couple of years. You probably go by it every day.
Sorry.
Yeah, but certainly in these photographs that have been provided in this application, it doesn't look like there's any visual impact whatsoever.
It doesn't, there's any visual, doesn't appear to be any need for any additional landscaping or anything of that sort.
So you need another motion that,
Same thing.
same motion as before?
Finds no planning or environmental.
No planning or environmental issues? Can I have a motion to that effect? Jesse? Second? Second. Sharon, all those in favor?
Aye.
Opposed? Abstentions?
Example of a couple of things that need to be tweaked in the ordinance.
Yeah. Ryan, anything you want to bring to our attention?
Nothing, as to courts wise, we just need an updated file.
Okay, Brennan, can you work with Ryan to make sure he's got... Yeah, there's been a lot of moving parts, so... Okay.
There should be some new applications coming in there too for remediation work. For the vegetation removals and things like that.
Any other business to come before us this evening? Woody? So moved. Second? All those in favor of adjournment?
Who was my second?
Aye.
Jesse?
Anybody.
Everyone.
All those in favor? Opposed? Abstentions?
Woody always makes...